that the only thing my constituents care about is whether they're going to be safer. So making your job easier isn't exactly my job. My job is to make my constituents feel safe. And right now, knowing that there's going to be cultivation on site at a dispensary possibly down the street from them or within city limits doesn't make them feel safe. So I'm trying to get to a point where I can explain it that this is going to be safe. And you don't have to answer every point unless it's like something different that you...
Well, I would say, though, that it's not about making my job easier. I think it's about what the voters voted for and what the law in California is. And it may be important that your constituents have certain concerns, but if the law in the state of California doesn't allow for something, it doesn't allow for it, regardless of what an individual citizen wants. Then the answer to that is a new initiative to change the current status of law in the state of California.
Which I believe is on the ballot, I think, anyway. So the next question is, you talked about regulating it, that it makes it more difficult for law enforcement to regulate. So you're talking about regulating what? The Attorney General's guidelines, regulating the local ordinance, regulating federal law?
Regulating whether or not the collective operators are complying with the law.
What law?
California law.
Okay. And then you talked about investigations. And California law requires it to be grown on site?
California law does not allow for transportation of marijuana on behalf of a collective.
So it could be grown someplace else, you just can't transport it.
That would be the point of that would be the location then of your collective.
Exactly.
If I grew it in my backyard and I can't transport it, my collective can come to my backyard and get it. Thus you have your dispensary.
Okay. So I guess my point is, if that's the law now, you should be able to enforce it now with the 60 collectives we have by sitting in the parking lot. I just, because I'm struggling with this, trying to let my constituents know that, hey, I understand that and I heard an earful this weekend, and so I'm just wondering how this helps when you're not doing it now. But the next question I have is on investigations. You said that it will help with investigations. What kind of investigations?
It will help with the regulation and the investigation of these collectives and the cultivations. It makes it very difficult when someone brings in, let's say, 65 pounds of marijuana and says, but I'm doing it on behalf of a collective, and they're growing it in another county. There's no way for law enforcement to know, without actually going there, whether or not the amount that's being grown is consistent with the members of the collective. If you have 10 members of your collective, you can't have 5,000 plants.
None of these collectives have 10 members.
Well, I'm saying that to make a point.
Yeah.
If you have 10 members of your collective, you can't have 5,000 plants. If you have 100 members, you can't have 5,000 plants. So it certainly allows the city to control and regulate, just like you do with alcohol and other substances. Allowing someone to cultivate as far away as Northern California or an unlimited location certainly makes it far more difficult and comes at a greater expense to the city if law enforcement believes that they have an illegal operation and goes on to investigate it. It's going to be far more difficult and cumbersome to do it someplace else than it's going to be within your own borders.
But you can still bust them even if it's within your own borders, I would hope.
Well, you're not going to know if they're cultivating it in Humboldt County unless you go and look.
Or on location number 2 via the Long Beach Ordinance. I mean, if they're taking it from one location to cultivation location to a location where they dispense it, what's the difference between that and taking it from one location in another county or outside the city to the dispensing area?
I think there's a huge difference.
I mean, is there like the only reason I ask is because a plant is a plant is a plant. So if you catch them a block away from a dispensary and they say, well, I cultivated this in the cultivation spot number 2 as mandated by Long Beach City Ordinance, as allowed by the ordinance within the city limits, I mean, they don't come with a tag on it. It doesn't say I was grown in, I just don't understand I'm really having a little bit of trouble with
I understand that you don't understand.
Yeah. Well, we all wanted to get to the logical part of it so I could explain it to my residents, and these are the questions that they bring up to me. So I hope that you bear with me because I'm trying to explain it on the doorstep almost every day when someone brings this up. And This is what they're asking. The other thing is indoor cultivation. You had mentioned that indoor cultivation is probably one of the more difficult because you have electronic services issues where there's fire, and these are from the notes I took from you speaking about the fire, the issues of armed guards, on-site cost issues, and everything else. But once again, so what do we need in an ordinance if we're going to mandate this community to do it on site? I mean, there would be like a whole list of.
Can I help you?
Yeah, please.
I think what the distinction that you are not making here is there is the illegal market and what we hope will be the legal market.
And right now, is everyone legal or illegal?
Both.
Okay, can you tell me what the distinction, if there's 20 collectors out there, and I don't know if there is.
Correct.
Which ones will be legal and which ones will be illegal?
What the law says that you can do is gather together to collectively or cooperatively cultivate marijuana. Mm-hmm. Okay? It doesn't say that you can sell marijuana, whether we talk about making a profit or not. So it says if the members of the council would like to come to my house to grow marijuana in the backyard, when the police come to my house and knock on the door, I'm going to say, hey, these are the members of my collective. Now, it doesn't say that I can grow the marijuana in my backyard and then bring it here to the city council and we can run the collective out of the front or the back door. This is what the law says. Now, I will absolutely agree with you that there is a lot of confusion in the area of the law, especially when we deal with all the different ordinances that everyone is trying to put in. My biggest recommendation for you would be follow the state law. That's.
And the state law says that you need to be able to. Now you had mentioned it. You said you can cultivate per number.
The state law 11362.775, which deals with specifically collectively or cooperatively to cultivate, only allows for that group cultivation and nothing else. There's a different section within the medical marijuana program that ends in .765 that talks about the individual immunities someone would have, whether you're a qualified patient, a card-carrying member, a primary caregiver, or any individual. It lists the different immunities and what you can and can't do under California law.
Okay, but it doesn't speak directly to on-site or off-site?
What it says is you can only cultivate, and in other areas it says who can and can't transport, and it doesn't make any mention of allowing someone to transport on behalf of a collective.
Okay.
So I think the implication is when the California Court of Appeal and the California Supreme Court tell us how you analyze this particular piece of legislation, it's abundantly clear you're only immune from, in other words, you're only allowed by law to do certain things authorized. It doesn't say that you can't cultivate in one location versus another. It says you can collectively or cooperatively cultivate, and you're immune when you engage in the act of cultivation. There's case law that says the only person who can transport is a primary caregiver or a qualified patient for themselves or the primary caregiver's qualified patient. That's it. There's no case law that says a collective can transport 60 pounds of marijuana across the state of California.
I have two. When I stopped last time I said three, so I have two left. I'm not a lawyer, but it would seem to me that the way it's written, you can almost talk about it. I mean, anybody can defend any aspect or say it's legal or illegal. But I have a question on the security and then one on the cartels. You said on-site, the security needed on-site in city locations. What would you recommend if we were to do if we were to agree to on-site or in city cultivation? What kind of security mechanisms would we have to require?
Well, I believe the Los Angeles city ordinance requires the collective to supply security guards, proper lighting, other security features, cameras, things of that nature to ensure the safety of those that go into the dispensaries and the collective workers and the rest of the community.
I believe we have that in our ordinance right now, even without the cultivation on site. So I'm just saying that's what we have now.